Hello, this is lecture 2 from topic 2, and the focus of this lecture is on limiting the power of the Supreme Court. Judicial review is one of the main powers of the judiciary, and we learned about that in the last lecture. The second half of the chapter looks at restraints on the power of the judiciary. 1. Congress's ability to define the Supreme Court's appellate jurisdiction. And we're not going to talk about that in lecture, but it'll be in the course overview for this week and also in your textbook, obviously. But today we're going to talk about, in this lecture, stickability, okay? And also standing, whether a person has standing. And so for the Supreme Court to hear a case, it must be stickable, and also the person that brings the case to the court must have standing. So let's look at what those two concepts mean. One restraint placed on the court is stickability. In other words, stickability is whether a case is appropriate for being reviewed by the Supreme Court. You can't review a case, the Supreme Court can't review a case if it's not stickable. So what makes a case stickable? Well, Article 3 dictates two requirements for stickability. One, there must actually be a case. In other words, there must have been some action taken that resulted in some sort of harm or damage to an individual or a person. That there must have been some sort of action taken that had some impact on another individual. So there must be a case. There also must be a controversy. And so there needs to be an action, but there also needs to be some sort of dispute, an actual dispute between individuals or parties. Because keep in mind, what courts do is they need to settle disputes. And so there actually needs to be a controversy, a disagreement between two parties. If there's no case, the Supreme Court can't hear from a person or review a case because it's not stickable. And if there's no real controversy, then also the Supreme Court cannot review that case. So let's look at specific examples of what constitutes a case and what constitutes a controversy. Your textbook identifies 5 characteristics of cases where stickability is a concern: advisory opinions, collusion, mootness, ripeness, and political questions. So let's dig in and take a look at each one of these. Let's start with advisory opinions. An advisory opinion is asking the court to offer an opinion on a hypothetical case. So, for example, let's imagine that the Congress of the United States was thinking about passing a federal law banning abortion after 16 weeks. And let's say that before they actually passed that law, they asked the justices to weigh in and said, hey, justices, if we pass this law, do you think that this law would be constitutional, or would it violate a woman's right to privacy? Well, regardless of how they would respond to that, and they wouldn't respond to it because the court does not issue advisory opinions, that's a good example of an advisory opinion if one was issued. Advisory opinions are not stickable. In other words, when asking the court to review a hypothetical case is not the kind of case that the Supreme Court can review. Why? Because there's no case, right? So remember that a case is when there's an actual action that is taken, and that due to that action, that there's some impact that that action has on another individual. Well, the law has not been passed. It hasn't been enacted. So there is no action to respond to. And so since the Supreme Court can only hear cases and controversies, they can't hear something that is not a case. Now, the Constitution doesn't explicitly forbid advisory opinions, but the Supreme Court has interpreted Article 3 where the word case is used over and over again, that the court has looked at Article 3 and has ruled early on that it, one, wouldn't issue advisory opinions, and even if they wanted to, they couldn't, because the Constitution does not give the court that power. Remember in your textbook that they talk about early on in 1793, during the first presidency of the United States, George Washington. Thomas Jefferson was George Washington's Secretary of State, and there was a war going on between Britain and France. And Jefferson really wanted the United States to come to the aid of France. Well, as your textbook points out, Jefferson reached out to the justices in the Supreme Court asking for, like, if we did this action giving aid to France, like, what do you think about that? Would that be constitutional? What might be some of the reverberations from that? And as you read in your textbook, the Supreme Court was like, no way, we do not issue advisory opinions. And they said for, one, that the hypotheticals are not real cases. You have to actually wait for the George Washington's administration to take action to respond to. But also that it violates the separation of powers. The executive branch implements, foreign policy. The Congress would declare war, right, or pass some sort of treaty. And then after that happens, then the court weighs in. That's how our Constitution is designed. And so it's for those reasons that the Supreme Court, early on ruled against advisory opinions, stating that they were not cases that they could hear because they are not cases. Now, just to think critically about it, that some states in the United States and other countries actually require judges to issue advisory opinions when asked. So think about, what are the benefits of issuing advisory opinions? Is there something good that would come from that? I mean, I guess it would be more expedient, because why would you pass a law if you knew that the court would, rule that it was unconstitutional? But a drawback could be that just because one sitting court thinks a law is constitutional doesn't make it so, and it's not until that law is actually enacted and we actually see the impact of that law that you could truly sort of evaluate the constitutionality of that law. Next, let's talk about collusive suits. Now, collusive suits have to do with the issue of collusion. In other words, are the parties to a lawsuit sort of secretly cooperating with each other to, achieve some sort of ends that they both sort of agree on, okay? And we'll look at some concrete examples of that in a second. Now, sometimes people will actually create a case to challenge the constitutionality of a law, and I have create there in parentheses. So a good example of that, you're going to actually be reading about a couple of examples of instances where people sort of create situations in order to purposely challenge the constitutionality of a law. The example I'll talk about here is Plessy versus Ferguson. But in your textbook, you're going to be reading about the landmark case DC versus Heller, which challenges the law in the District of Columbia that forbids the purchasing of a handgun, and that the individual Heller who was used to challenge that law was sort of handpicked in order to make like the strongest case possible to come before the Supreme Court. Plessy versus Ferguson is a good example of that. That in Plessy there was this was a case that challenged the Separate Car Act in Louisiana. Louisiana law in the book saying that black folks had to ride in one train car and white folks had to ride in another train car. And if a black person went into the white car, that they would be charged with violating the Separate Car Acts. In that case, a group of individuals called the Committee of Citizens tapped this individual, Homer Plessy, and encouraged him to violate those laws. And he agreed, and so he, was a light-skinned black. That's actually kind of why it was tapped to challenge the Louisiana law, to sort of show the absurdity of dividing people on the basis of the color of their skins. Regardless, these kinds of cases the Supreme Court can hear. These would not fall into the category of collusive cases. And that's because that even though Homer Plessy was identified and agreed to riding a train car at a certain time and agreed in advance that they were going to go into the white train car, that the state of Louisiana was opposed and to that action. The state of Louisiana, the Congress of Louisiana supported the Separate Car Acts. They thought that was the good law. And so that there wasn't collusion. The state of Louisiana was fighting to support those laws, and Plessy and others were fighting against those laws. So there's an actual case and there's an actual dispute to be settled. A collusive state is when opposing parties are sort of working secretly behind the scenes in order to challenge a law, to test the constitutionality of a law. And the Supreme Court can't hear these kinds of cases. They use the example in your textbook of Muskrat v. United States is a good example of a collusive case. In that case, the United States had laws on the book regarding the distributing land to Native Americans. And there was some question about whether or not the laws that were on the books were constitutional. And so the United States government passed a law allowing Native Americans to challenge the constitutionality of those laws. And in fact, that members of Congress agreed to pay for David Muskrat's suit. It's basically like supporting him and suing the United States. And both Muskrat and the United States were sort of wanting the same outcome, right? They wanted those laws to be found to be unconstitutional. And so the Supreme Court ruled in Muskrat versus the United States that kind of case, it's a collusive case and it's not justiciable. And why is it not justiciable? Well, there's a case, so an action has been taken, but there's no controversy, right? There's no disagreement between David Muskrat and the United States. They both want the same thing. They both want these laws to be deemed unconstitutional. Now, keep in mind that your textbook talks about that just because the Supreme Court ruled this way in Muskrat versus United States, there are actually times when the Supreme Court will take on collusive cases because they think that while it may not be a controversy right now, it may be a controversy in the future. So it's not necessarily a hard and fast rule. Okay, let's talk about moot cases. Now, the court can only hear actual live disputes, right? Remember, the court settles disputes, and so they can only review cases where the dispute is actually still going on. If there's no longer a dispute to settle, the court can't hear the case. It is known as a moot case, and moot cases are not justiciable because there may be a case, but there's no more a controversy. Now, let me give you some examples of cases that deal with the issue of mootness, raise the issue of mootness, okay? Now, I know several of you students took my sex, power, and public policy class last semester, who are in this class this semester. And so I wanted to, and this is good for other students as well, I just wanted to remind you of the crazy case, Craig v. Boren. In Craig v. Boren, remember that was a case about a state that had different age requirements for beer purchasing. Ladies could purchase beer at the age of 18, but guys, because they're immature or whatever, they had to wait until they were 21 in order to purchase beer. And remember that state law was being challenged as violating the Equal Protection Clause. Well, why am I telling you about this case now? Well, I'm telling you about it because remember that while they were litigating that case, they had to keep coming up with a new litigant who was suing the state. Why? Because as time went on, the 20-year-olds who couldn't buy beer would turn 21, and so now they could buy beer. There was no longer a dispute to settle. The case was moot. So they had to keep coming up with younger litigants as they were still preparing for the case to work its way through the court in order to mitigate against mootness. Your textbook also talks about Defundus v. Odegaard and Roe v. Wade as an example of a moot case and a not moot case. I'll just leave it to you to read those two cases now that you have a better understanding of mootness. All right, now let's talk about case ripeness. Now, ripeness is the opposite of mootness. Moot, when a case is moot, the dispute has been resolved or the dispute is just no longer alive. It's a dead dispute, and courts can't hear cases that don't have disputes. If a case is not ripe, the dispute just hasn't happened yet. It's like a pre-dispute or a potential dispute. Justiciable cases must be ripe. The dispute has to be happening at that time. Why? Because justiciable cases have to have a controversy. Controversies have to be taking place. They can't be resolved, or the controversy can not be something that is presumed to happen, but that hasn't happened yet. So the reason you think about ripeness and cases that lack ripeness is sort of similar to advisory opinions. It's not yet a controversy, yet we're trying to get the court to weigh in about if that controversy does happen, is the harm that came from this dispute, right? Or is this law that has caused this controversy, this dispute, is that law constitutional? Your textbook uses the example of the United Public Workers v. Mitchell. In this case, it's about the Hatch Act that's passed, and the Hatch Act is basically saying if you're a federal employee, you can't engage in any political activities or actions, and if you do, you'll get in trouble. And so you'll read about in the textbook how there were some federal workers, and they were like, oh no, we're going to get charged for violating the Hatch Act. And the Supreme Court said, no, you actually have to wait to actually be charged with violating the Hatch Act. And only one of their coworkers had actually been charged, thus creating a controversy, a dispute to be settled. Okay, the last justicable issue that we're going to be looking at, and thanks for hanging in here. I know this may not be the sexiest of topics, but it will really be important as we move forward and we're reading different cases. But the last issue we're going to look at is political questions. And so another type of non-justicable suit involves what is deemed as political questions. And these are questions that can involve a constitutional matter, but that the court decides that they should not be reviewed because it's better that the controversy is solved in the political arena rather than in the courts. And so what does that mean? Well, they use a good example in the textbook of Nixon v. United States. Now, just to be clear, it's not that Nixon, okay? Nixon versus the United States, 1993. This isn't about Richard Nixon. There is actually United States v. Nixon, and that's about what presidential privilege and whether or not tapes are privileged. So there is actually a case, United States v. Nixon. But this case is not about Richard Nixon. It's about Walter Nixon. And Walter Nixon was a federal district judge. He was convicted of felony for making false statements to a grand jury, and then he was impeached. And so oftentimes when we think about impeachment, we think about only the president being impeached. But all federal officers can be impeached, and justices are impeached if they engage in some, a high crime, bribery, treason, or other high crime and misdemeanor. And so the Nixon versus United States is about the impeachment procedure in the House and the Senate. And Walter Nixon felt like the procedure had not been followed, and that he asked the Supreme Court to rule on whether or not the procedure for impeachment had been violated. And the Supreme Court said that they would not do that. What they basically said was that for one, impeachment is left to the Congress to decide basically how to do impeachment under Article 1. And so it wasn't for the court's job to interfere with Article 1. Article 1 is basically governs Congress, and impeachment and the way that it is handled, those procedures, is left to Congress. But also, they were sort of pragmatic as well. I mean, they were basically saying, look, I mean, what if the court did intrude on impeachment proceedings? My God, that would create huge confusion. Because if somebody was impeached, they would just litigate it up to the Supreme Court, and then the Supreme Court would rule. And then what if a president had been impeached and removed, but then the Supreme Court had determined, well, the procedures were not correct. So what does that do? Still the president, or a lady still the president, etc. So that's a good example of the political questions that sometimes certain, even though it might have to do with the constitutionality, that just given the chaos that would come from the court weighing in, they will refuse to hear those kinds of cases. All right, the last thing we're going to take a look at as it relates to stickability is the issue of standing. Up to this point, we've been talking about the case itself, right? We're saying, is there a case? Has some action been taken? And then also, is there some sort of controversy? Is there a dispute that needs to be settled? Standing has to do with the party that is bringing a case to the court for review. And so that courts can only review cases in which the party actually has standing to sue, okay? It could be a case and it could be a controversy, but the person who's asking the court for a remedy may not actually have been harmed by the law. They may not have standing to sue. So let's look at what constitutes standing, and then we'll close this out by taking a look at a religious establishment case that brings the issue of standing to life. So for somebody to have standing to sue, they actually must have been harmed by the law or harmed by the action of a government official. That the harm that they have suffered must be traced back to the person or the party that's actually being sued, okay? And then also that it must show that a favorable court decision, if the court rules in the favor of the person who is suing this other party, will they get some sort of relief from that? I'm going to use the example of Tinker v. Des Moines, which we're going to talk about later this semester when we talk about freedom of speech and whether or not students, the First Amendment applies to the speech activities of students. Tinker versus Des Moines, as you can tell by that date, that took place during the Vietnam War. And that there were some, in Tinker versus Des Moines, that there were some students who had planned a protest. And part of their protest is that they were going to wear armbands to school, basically protesting the Vietnam War. When the school board and the principals of the Des Moines School District found out about this plan, they passed a policy saying that any student who wore an armband to school would be asked to remove it. And if they didn't remove it, then they would be suspended. They would be asked to leave school. And so 3 students, Mary Beth Tinker, her brother, John Tinker, and a friend of theirs, Christopher Eckhart, they knew about the policy, but they thought that it was their freedom of speech to wear the armband. And so they wore the armband to school, and then they were kicked out of school for that day. And so the Tinker family sued the school district of Des Moines for harm. They said that their children were their freedom of speech rights were harmed. They were also harmed because they were suspended, and they were asking for relief, that saying that they had the right to protest, that was guaranteed by the Constitution, and therefore they should not have additional punishments that would come their way in terms of additional suspensions. We'll learn how the court rules in that case. I don't know, spoilers here, in a few weeks, but that's a great example of the Tinker children on behalf of their parents who have custody of them, that they had standing to sue. They were harmed, and that the school district is who harmed them, and that if the court ruled in their opinion, then they would get a redress to the harm that they had sustained. So here is an example of a case where an individual does not have standing to sue, at least from the Supreme Court's perspective, and I agree with the ruling in this. This is a case called Elk Grove Unified School District versus Newdow. And this is a case about a father. His name is Michael Newdow. And his daughter, he's the father of a daughter that attends the school, the Elk Grove Unified School District. And that school district had a rule on the books that said that his daughter had to compelled his daughter to recite the Pledge of Allegiance, including the phrase "One Nation under God." And Michael Newdow is an atheist, and he's a strong supporter of the separation of church and state. And so he sued the school district, saying that compelling his daughter to recite the Pledge of Allegiance, including having her say "One Nation under God," was a violation of the Establishment Clause. And it also violated his ability to raise his daughter as he saw fit in terms of her religious upbringing or the lack thereof. This case made its way up to the Supreme Court. There was disagreement in the lower courts about whether or not compelling a child to recite the Pledge of Allegiance violated the Establishment Clause. But the Supreme Court, they dismissed this case. They agreed to hear it, but they dismissed it because they said that Michael Newdow did not have standing to sue. And you're like, what? Why not? He's the father of this child. The Tinkers family had standing to sue. Why wouldn't Michael Newdow? Well, as it turns out, Michael Newdow was not the custodial parent. That him and his wife were divorced, and that the custodial parent was the mother. And so the mother made choices about where the child went to school and made choices about her religious upbringing. As the non-custodial parent, he did not decide her religious upbringing. He did not decide what school that his daughter went to. The mom did that. And so that the Supreme Court said that since he didn't have sufficient custody over his child, he couldn't claim loss or injury. That you can't lose something, control over religious upbringing, that you don't have, and therefore you don't have standing to sue. That's an interesting case because it's like the Supreme Court, you're like, well, why did you agree to hear that case if you were going to rule on standing? And the court does that sometimes to clarify standing issues, but also because maybe they just don't want to rule in the case. Michael Newdow did not give up. He kept suing the school district, but from this point forward, the Supreme Court has never granted this case a writ of certiorari, and it probably never will. All right, a little taste tease for our next when we actually get into cases, because the religious clauses are the first thing that we do. All right, thanks a lot for listening, and I will talk to you again soon.